Alright, brace yourself. Because this transcript is basically a highlight reel of the court doing damage control in two totally different cases, and both of them scream the same message. Your choices outside the courtroom follow you inside. First, you've got a defendant who admits, casually, he smoked marijuana last night, right before court. That's not just bad timing. That's a direct bond violation and the fastest way to get the judge to slam the brakes on everything. No deals, no paperwork, no shortcuts. Because the court can't responsibly move forward if someone might still be under the influence. And the judge doesn't just scold him. She punishes the decision. Bond increase, drug patch, reset, and a cold reminder that court isn't a place you show up impaired and hopeful. Then the video pivots into a second case where the stakes change, but the energy stays the same. Probation violations on a meth possession felony with a 10-year maximum hanging in the background. And somehow the defendant is smiling like it's a joke, until the judge lays out the math. Technical violations stack into real jail time, and if you keep pushing, probation turns into prison. This is one of those episodes that shows exactly why judges obsess over compliance. Because in their world, one careless decision becomes a chain reaction. Question for you. Should judges treat these technical violations as serious as new crimes? Or is the system built to catch people slowly?
Ms. Holmes, Isaiah Brown. See, this is Mr. Hoff Powers. Thank you. So when's the last time you smoked marijuana?
Last night.
Last night? You thought that was a great idea to smoke marijuana the day before you were coming into court?
Judge, you're going to want to read the back of his hoodie.
Turn around. Turn back around.
It's the only clothes I got now. Like,
Yeah, 1 point.
Well, maybe if you weren't spending money on drugs, you'd have some money to go. You can go to Goodwill and buy a new shirt for $5, for $2. So I'm not buying that that's all you have. And if it is all you have, then that's a choice that you're making. I'm going to find that you violated the condition of your bond. The fact that you smoked marijuana last night is absolutely ridiculous. You're making terrible decisions, and there's nothing I can do today because you could still be under the influence. And so we're not going to go through any paperwork and take any plea deals while I think you might be under the influence. So to make sure that you're not under the influence next time you come to court, I'm going to raise your bond in your case to $50,000. A condition of that bond, if you make it, is to have a drug patch on at all times. And you can go back with the bailiff. We'll reset the case. I'll reset it for the final docket of the year, which will be that Tuesday, the 16th. Okay. All right, so he doesn't have to wait the whole time, and we'll see how things go at that time. I am going to delete the paperwork. Y'all will have to do it again.
Yes, ma'am.
That bond increase to $50,000 plus a drug patch 24/7 is the judge basically saying, you don't get the benefit of the doubt anymore. A drug patch isn't about a single pass/fail test. It's ongoing accountability. The court is building a paper trail, so next time there's no debating, I didn't use, or it was secondhand, or it was days ago. It's also the judge protecting the integrity of the case, because if you keep showing up in a questionable state, the court can't trust anything that happens in the courtroom. And notice the judge deleting the paperwork and making them redo it. That's not just inconvenience, it's consequence. It tells everyone in the room, your decision wasted court resources, and I'm not rewarding it. Courts run on schedules, and showing up impaired throws a grenade into the system. Now here's the retention pivot. The video immediately shifts to someone else, Jessica, who's not even asking for mercy. She's asking for time, a new attorney, and somehow, Christmas. That transition is wild. Question, should the system be more flexible around holidays? Or does trial is tomorrow mean exactly that, no matter what?
Ready? Yes, ma'am. I have Jessica Cantu on page 5, 4 down.
oh, different.
Jessica Cantu?
That's what we're about to talk to you about.
Okay.
Just fire transfer.
All right. All right, make you happy.
Okay.
Stand right there. Hold on 1 second. I'm going to address you, okay?
Hello. So what is happening with this case?
Judge, I think Ms. Cantu and I are having a difficult time communicating with each other, and he would like to be represented by other counsel.
All right. Are you able to afford an attorney?
That's what I was trying to explain to him, that my dad, he came to see me and he said that he was going to try to get me another attorney and to bail me out, since I didn't know the bail bonds were like $5,000 and $2,000 or something like that, and he might have them by this week.
All right. So this case has been going on since November.
Yes.
So it's going to be recalled for tomorrow. And you'll either be in jury trial or either you'll have a new attorney. And if you have a new attorney legally, according to the law, they don't get 10 days because you've hired an attorney. So if we're not already in trial, you're going to be in trial tomorrow.
Is there any way that I could I don't know how to name. Up here, one had came to see me, and I don't know if there's any way I could spend some time with my family, like Christmas and stuff like that.
I'm sorry, what?
If there's any way that I could spend time with my family, like Christmas and New Year's.
Your jury trial is going to happen tomorrow. And if you want to speak to your attorney about your options, you're more than welcome to speak to your attorney about your options. But you have two cases, and according to what's on the docket, both of those are state jail felonies. I don't know if there's been any enhancements. So on those two cases, the range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine.
Yes, I'm sorry. He was talking about taking it to trial. That's what he mentioned.
All right, so we'll be back here tomorrow. They'll have you dressed for trial.
Okay, we could take it to trial.
Sure.
Yeah, okay. Could I do that?
Yes.
Okay.
Counsel, do you want a bench trial or a jury trial? With a bench trial, the person who will decide whether you're guilty or not guilty will be the court, which is me. What I can tell you, if the state proves their case beyond a reasonable doubt, I'm going to find you guilty. If they don't, I'm going to find you not guilty.
Is there any way that I could reset for like about a week from now, so I get enough money to?
No.
Okay.
This is a state jail felony, and it's been going on for a while now. It's a relatively simple case.
About a 12.4.
That has to do with punishment, and you'll need to speak to your attorney about that.
Okay.
So if you want to talk to him and talk to the state, and y'all can discuss offers, and if there's an agreement, the court will hear it. All right, thank you. Anyone else ready?
Yes, ma'am. Roger, then page 1.
Who is Callie Jones?
Are you Leah Misek?
Yes, I am.
The court will call next then the matter of people of the state of Michigan versus Leah Misek. This is file number 24-5316FH.
Sierra Coke on behalf of people.
Thank you, Your Honor. Richard Trushpan on behalf of Ms. Meese.
Ms. Misek, I'm Judge Hunter. I'm here to arraign you on an allegation of probation violation, 4 separate counts of violations. Have you had a chance to read and do you understand those allegations?
Yes.
That didn't seem like a very convincing yes. So have you had a chance to read the probation violation allegations?
I didn't read it. No, my probation officer just told me that I had court.
Well, let me read the allegations to you, Ms. Misek, because they're fairly serious. You're on probation for possession of methamphetamine. That's a 10-year maximum felony offense. The allegation is that you failed to report in count 1 on June 3rd of 2025, that you failed to report in count 2 on August 5th of 2025, that you failed to report on count 3, 11/4 or November 4th of 2025, and that you, in count 4, failed to pay court assessments as ordered. Do you now understand those allegations?
Yes, I understand them, but I've been coming.
No, don't talk about what happened.
Ms. Misek, you appear to be treating this matter as somewhat comical. That confuses me very deeply because when you have a smile on your face and I'm arraigning you on 4 different probation violation allegations, I think perhaps you don't understand the seriousness of the situation. A first technical violation is punishable by 15 days in jail. A second, punishable by 30 days in jail. A third, by 45 days in jail. And if you're convicted of all of the technical violations, up to the maximum that you're on probation for, meaning up to 10 years in the state prison system. Given the severity of those allegations, it obviously would then deeply concern me that you would smile when I'm telling you what the potential allegations are. You have a right to remain silent, and anything that you say on the open court record today can be used against you. You have a right to a contested probation violation, and you have a right to that hearing within 14 days if I set a bond that you cannot post. You have a right to be represented by counsel, and if counsel cannot be afforded by you, you would have counsel appointed to represent you. Do you understand all of those rights?
Yes, sir.
Mr. Trush, has Ms. Misek been screened?
Hey, John, she has. Mr. Thompson will be appointed on that matter.
In terms of bond, Mr. Haven, Mr. McFall, I'm sorry, this is your case, correct?
It is, Judge. At this time, I'm just going to ask for a PR bond. The goal here is Ms. Misek needs to report when she's supposed to report to her supervising agent in Grand Traverse County. If she could do that, there won't be any further issues, and at some point I'll probably just dismiss this violation. So I would just ask that violation hearing be set out 60 days so I could just ensure she's reporting as directed. That's just kind of been an ongoing problem here that's kind of festered into this court action.
Ms. Cope, do you oppose that suggestion?
No.
Mr. Church, do you?
No.
Ms. Misek, were you able to clearly understand and hear what Mr. McFall just indicated?
Yes, sir.
His intentions are helpful to me and generally accepted or at least considered seriously by me, but they're not controlling on me. And so I want you to clearly understand that whether or not Agent McFalda ultimately wishes to dismiss these probation violations, I'm not bound by that. In other words, I can decide to proceed forward on these violations. And these violations, again, are not insignificant. The simple request by your probation agent on a 10-year felony is that you report as and when required. Do you understand that?
Yes.
You had better get back into practice of reporting because that's a very basic tenet of probation. If you don't, then I'm going to have to decide how to proceed absent those requests being followed. Do you have any questions before we break, Ms. Misek?
No.
At this point, I'm going to hesitantly decide that a PR bond is appropriate. I'm going to set a probation violation hearing in person in 60 days from today's date approximately. You'll get a notice for that in-person proceeding here in Crawford County. If I receive information from Mr. McFalden and he convinces me that it's appropriate, I might determine to dismiss the allegations. If that's the case, you'll get a written order dismissing them. Unless and until you get that written order, you're required to be here in person at that next court date. Do you understand?
Yeah.
You better talk with your attorney and make sure you fully understand all of the things I've said today so that he can give you proper advice. Anything else, Ms. Cope?
No.
Anything else, Mr. Church?
No.
You're all set today, Ms. Misek. Thank you.
Thank you.
And Mr. Thompson, if you could unmute.
That's all, folks.
Here's the professional wrap-up. Because this transcript shows 2 different courtrooms delivering the same warning in 2 different ways. In the first case, the defendant admits he smoked marijuana the night before court, and the judge treats it as a direct violation of bond conditions and a potential impairment issue. Because of that, the court refuses to move forward with any plea paperwork, raises the bond to $50,000, orders a drug patch at all times as a condition if he bonds out, and resets the case, making it clear that compliance is not optional. In the second case out of Michigan, Ms. Mick is arraigned on 4 probation violation allegations tied to a probation term for methamphetamine possession, a felony with up to a 10-year maximum exposure. The judge sharply corrects her attitude, explains escalating jail consequences for technical violations, advises her of her rights, and, hesitantly, grants a PR bond with a probation violation hearing set about 60 days out, warning that dismissal is not guaranteed unless there's a written order and she starts reporting properly immediately. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, And don't forget to subscribe for more jaw-dropping courtroom breakdowns.